In 2017, this precedented claim by Mr. Bivens in his case against 6 unknown narcotics agents had raised an issue once more before the nation's highest court, but this time in connection with the September 11th terrorist attacks, when the United States government had ordered hundreds of illegal aliens to be taken into custody and held pending a determination whether a particular detainee had connection to terrorism at all, and the custody under what had been described as harsh conditions had continued, in many cases lasting for days and weeks and stretching into months. And unlike many in pandemic, some of these aliens, not even citizens, have been detained but filed suit, leading to a case that has been brought all the way to the Supreme Court, titled Ziegler v. Abbasi. The complainant had named as defendants 3 high executive officers in the Department of Justice, 2 of the wardens at the facility where the detainees had been held. And again, the lawsuit had been commenced in the city of New York in federal court, not on social media or in some panel discussion. A court accepts as true the facts alleged in the complaint, and provided a plaintiff brings facts to establish a legal cause of action, a complaint should survive a motion to dismiss. And many seem to have complaints about deprivations of liberties in pandemic, but apparently only criminals go to court to defend their rights. These illegal aliens had still come to court, even though the federal courts had consistently refused to extend Bivens to any new context or new category of defendants for the prior 30 years before 2017. Now, even the courts tend to grant deference to the government, and especially to the executive department, under the precedent of Ziegler v. Abbasi. The proper test for determining whether a case presents a new Bivens context is first to determine whether your case is different in any meaningful way from the previous Bivens cases that have been decided. If not, then obviously the context is new. You had a once-in-a-lifetime pandemic, which is new, involving a novel virus, which is new, and a new vaccine, which is new, but probably never even contemplated taking a complaint to a court, like some criminals apparently do. A case might differ in a meaningful way because the constitutional right at issue is different. The generality or specificity of the official action, the statutory or other legal mandate, or the presence of potential special factors that previous Bivens cases did not consider. However, one can only speculate because nobody in a pandemic, until now, brought that case. Even a modest extension is still an extension. And a pandemic, one would even reflexively assume to import some even remote nexus to national security, having been all over the world. Or else why would the intelligence community have been involved to help try to solve the mystery about the origins of the virus? By executive order, the intelligence community is strictly limited to investigations of only matters of national security, and generally are prohibited by law from attempting to expand their intelligence activities, even into nursing homes or grammar schools, particularly after abuses had been discovered during the Watergate scandal. Many have heard about terms like qualified immunity and claims brought under Section 1983. However, Section 1983 only applies to state officials, and Congress did not create an analogous statute for federal officials. A Bivens claim, however, embraces the broader context, invoking a federal-type common law, seeking to move beyond the strict text and plain word meaning of statutory enactments to address a manifest injustice. Accordingly, the Supreme Court has concluded that Congress had not foreclosed a damage remedy in explicit terms, and that no special practice suggested that the judiciary should hesitate in the face of a congressional silence. But someone has to bring a case. This court, the Supreme Court, accordingly, had held that it could authorize a remedy under general principles of federal jurisdiction if someone were to bring it into a court. There is no question that the courts have said that even violations of the FOIA can be read to state a Bivens-type claim for constitutional violations. And the Supreme Court has held that only individual federal employees, however, or officers may be the subject of Bivens actions. Allegations must be specific and not general allegations against the entire government or even an entire government agency like perhaps the CIA. To adequately plead scienter, plaintiffs must plead facts that create a strong inference that someone with a name, with a job, whose intent could be imputed to the government had acted with the requisite scienter. A set of law Bivens in the sphere of law enforcement, having arisen from 6 narcotics agents coming into a man's home in New York, and the undoubted reliance upon it as a fixed principle in the law are powerful reasons to retain it in that sphere. However, most recently, the Supreme Court in Mesa v. Hernandez had granted certiorari, but the lower court had reasoned that such an incident had presented a new context and that multiple factors, including the incident's relationship to foreign affairs and national security, were present. To the extent that defendants are violating clear and mandatory or ministerial duties, plaintiffs may even have an ultra-virus cause of action to challenge, as an excess of statutory authority or a similar cause of action for mandamus relief. Clearly, our whole Constitution and its heritage rebels at the thought of giving government the power to control minds. If there is any fixed star in our constitutional constellation, it is that no official high or petty can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or for citizens to confess by word or act therein. The existence of a crisis does not mean that inalienable rights recognized by the Constitution suddenly become unenforceable. If a statute purporting to have been enacted to protect the public health, the public morals, or public safety has no real or substantial relation to those objects, even the Supreme Court has recognized that where it is a beyond question a plain palpable invasion of rights secured by fundamental law, it is the duty of the court to so adjudge and thereby give effect to the Constitution. But somebody has to bring the case. The courts don't act for themselves. And here is the rubber. In the rule of law, no power can be exerted unless it be found in some express delegation of power or in some power to be properly employed therefrom. Written messages are not communicated unless they are read, and reading requires an affirmative act. Moreover, non-technical words and statutes are taken to have been used in their ordinary sense and acceptation. Hence, as always, we must begin with the words of a statute, creating the commission and delineating its powers. The terms of the agreement were clear and unambiguous. Before an EUA may be issued, the Secretary of HHS must declare that certain circumstances exist justifying the authorization based on only one of 4 determinations. While an EUA may be issued based on a determination by the Secretary of Homeland Security that there is a general domestic emergency for normal people involving in heightened risk of attack with a chemical, biological, radiological, or nuclear agent, such determination was never made. Nor had there been such a determination even rendered by the Secretary of War to protect military forces under his command. Yet on February 4th, 2020, and then again on March 27, 2020, the HHS Secretary had determined, pursuant to his authority under Section 564, that there is a public health emergency that has significant potential to affect national security, defined as military forces, or the health and security of United States citizens living not in the continental United States, but abroad, and it involves a novel new coronavirus, first detected in Wuhan City, Hubei Province, China, in 2019. The virus is now named SARS-CoV-2, which causes the illness COVID-19. In accordance with this provision of law, and acting upon his sole authority, the HHS Secretary can only render a determination that there is a public health emergency or significant potential for a public health emergency that affects national security or United States citizens residing or living abroad, that involves a CBRN agent. The term CBRN relates to most specific hazards that may be encountered during an incident and is generally reserved for the deliberate release of hazardous materials, such as in terrorist attacks. Whereas the term hazmat is used for accidental release or exposure to toxic industrial materials, or even a lab leak. Hence, under the law, any other use for this term, CBRN, would constitute an unauthorized commitment for contracting purposes and the Federal Acquisition Regulations, or FAR. And so, at least according to the law, what had been described as a highly contagious disease had been in fact a biological weapon deployed maliciously in attacks, an emergency use authorization, circumventing the normal procedures for approval by the FDA for private label marketing, could not be issued lawfully for any other purpose. The scienter of officers or directors who were involved in the dissemination of the fraud may also be imputed to the government or corporation, even if they themselves were not the actual spiker. While in the normal course, certainly one cannot be expected to disclose facts of which he is ignorant, consideration may be warranted for an exception to the mistake of law is not an excuse, in which the quintessential examples were individuals acting in reliance on a specific statute later held to be unconstitutional, or a court decision that a statute is unconstitutional. But that is not present here. In enacting the Biological Weapons Act, Congress had sought to protect the United States against the threat of biological terrorism. If Congress had wanted to authorize any other conditions in any way, it would have said so. And in U.S. v. Perez, the courts had held that defendants cannot dispute that COVID-19, often described as a highly contagious and deadly virus, falls within this definition, a biological weapon being deployed, not a highly contagious disease. And now this matter is being raised before the Supreme Court, where under the Constitution, all cases and controversies are decided. This message was approved by Major Mike Webb. Honest.
It's quaint. Always.